with an objective of it, that the building.
Thank you. Hello, this is Patricia Steele, one of the affected property owners.
Good afternoon.
Good afternoon.
Good afternoon,
Hi,
Judge. This is...
Go ahead.
Oh, please.
Go ahead. I think so. Hi, this is Alexandra Wilson from Sullivan Barros on behalf of the owner of 1713 Q Street, the intervening party. Thank you.
Your Honor, this is David Mallof. I'm the spouse of Patricia Steele, and very apologetic for my mistake on the last status hearing. I deeply apologize. Thank you.
Thank you for that. Are there any other parties on the line? All right. I should also let you know that we do have Judicial Clerk Philip Wrightson. He is Judicial Clerk here with the Office of Administrative Hearings, and he's just participating for observation purposes.
Welcome. Thank you.
All right, we are officially on the record. Today's date is March 15th, 2023. The time is now 3:32 p.m. Again, my name is Millicent Newhouse. I'm the administrative law judge who will be presiding over this case. This is the case of 2023-DOB 00001, the case of David Mallof and Patricia Steele versus Department of Buildings. This status conference hearing is being held remotely, and we're using a platform called Cisco WebEx. So this case, as I think was mentioned, was originally set for a status conference on March 3rd, and thank you, Mr. Mallof. You did send an email the same day explaining what had happened, and we understand that these things do happen from time to time, so I'm glad that we're all here today.
Thank you, Your Honor.
Thank you, Your Honor.
All right. So the purpose of the status hearing, we won't be having testimony or argument today. We will really be clarifying the issues, and if there are any areas of agreement, any motions that need to be raised or need to be addressed, we'll be talking about things like that. So the other thing I want to make sure and raise for you all, we like to make sure the parties are aware of the opportunity, and we strongly encourage participation in mediation. With a mediation, you may be able to come up with a compromise and reach an agreement that the parties can live with. Versus with an evidentiary hearing, I'm bound by the law and the rules, and there really is no opportunity for compromise. A mediation will be conducted by another individual in the Office of Administrative Hearings, someone who's been trained in mediation. If you aren't able to resolve the case, it would come back to me, and we would go forward with an evidentiary hearing. You should note that mediations are confidential, so all I would know is that you were able to resolve the case or that you weren't, and again, we would then schedule it for a hearing. I have found that it is often in the party's best interest to at least try and resolve the case mutually with the parties with the help of a professional mediator. Sometimes when people get our rulings, no one is happy with our decision, so I raise this as something that I hope you all will consider. You should also know that at the conclusion of an evidentiary hearing, I will not be making an oral ruling. We make written rulings in this case, and so that can be months out before you would get a written decision. So all things to consider. So at this point, I want to ask each side if you're willing to participate in mediation. And I'll start with you, Mr. Mallof and Ms. Steele, and then the department, and then the other interested parties.
Well, Your Honor, in principle, I think we're not uncomfortable with it, but we're able to speak shorthand with the department here. If only we could speak with them. We have heard nothing from them. I'm confident that we're steeped enough in this, and they're the experts. This could move along if we could only speak, and we did submit.
Did you happen to see the motion submitted by Ms. Wilson?
No. Yes.
Yeah, they submitted it. Okay.
very short. I think it was just we have an interest. I didn't think that was delineated.
I saw that.
Yeah, and I took that to mean that it was as a permit holder. Our feeling, Your Honor, is that Pat and I have talked about this at great length. We feel that the essence of this case, in part, is the absence of dialogue when dialogue was promised from the first day in August. And we sort of feel that by the permit applicant, Mr. Waldman, walking away 7 days after he attested that he would communicate with us, that really constitutes his abdication and his rejection of the process, and that it's a little bit late now to be coming in and saying they have an interest. He relinquished that right by not following the very form that he attested to that was legal, promulgated by the department. So, in our case, by the way, Your Honor, one last point is we question the conduct of the agency here. The agency is supposed to be adult supervision over neighbors and eager permit applicants and maybe recalcitrant neighbors in each of the worst cases, and they didn't do their job here. And so our challenge, and this is an administrative court, I don't think we're allowed to question the permit holder very deeply here, but they walked away, and the agency shouldn't have proceeded the way they did. This is regarding DOB.
All right.
We welcome them as you mentioned, interested parties. That's fine.
All right, and Ms. Wilson, I'll give you an opportunity to briefly discuss your motion. Sure. Thank you so much, Your Honor. The subject of this case is the DOB issuance of the underpinning permit. So our client has a substantial interest in subject matter of these proceedings, and our client's interest will be inadequately represented without intervention because the district's attorneys are solely representing the District of Columbia's interest in the proceedings. Naturally, I heard you note the 2 against 1. We may take similar positions on the issues. We'll work with the Office of the Attorney General to make sure we're not duplicating efforts on our end or burdening the court or the petitioner with duplicative information to respond to and filing. But the intervener status preserves our interest in the event that DOB's interests are not aligned with our client's interests, as again, the district's attorneys are solely representing the district's interests in this case. All right, thank you. And Mr. Moeller, you can articulate the department's position as well.
Again, Your Honor, we have no objection and are persuaded that prospective intervener has a compelling interest in this proceeding. It should be admitted.
All right. So as I mentioned, we don't do oral rulings in this case, but we will, though, submit a written response on the motion, and we'll do that in the near future because I know everyone is interested in how the case is going to proceed and who the parties will be in terms of participation. So going back to the mediation question, I think I'm hearing, at least from the 2 parties at this time, that you are interested in participating in mediation. And correct me if I'm wrong on that.
No, Your Honor, though we would look forward to an opportunity at hearing to present overwhelming evidence that petitioner's concerns were addressed by the Department of Building, perhaps not to his satisfaction, but insofar as the law is required. Notwithstanding, we would welcome the opportunity to mediate.
All right. And with mediation, you don't lose, if you don't reach an agreement, then we'll have an evidentiary hearing. We'll have our full hearing, and everyone to be heard and to present their testimony and evidence.
Understood?
All right, thank you. And I thought I might have heard someone about to say something else.
No, Your Honor, it's we trust in your judgment, and I just think I'd rather you hit both of us with a small stick and tell us to get back in the room. But that's we haven't heard anything from Mr. Moeller since Thursday, so.
Well, in a way, I actually
Your Honor,
yes, go ahead, Mr. Moeller.
I'm sorry, Your Honor, but I don't think 3 days is a very long amount of time with which to respond to an offer of settlement. I take exception to petitioner's characterization of me as somehow turning a deaf ear to his proposed settlement.
Thank you for that, and I do understand. I understand, Mr. Mallof and Ms. Steele, I think the frustration. This is, a case that's very personal to you, and you have, a great interest here. But I do also understand the department and how busy they are, and I do think 3 days is not a long time to be waiting to hear back. I think given the caseload that I happen to know the department representatives have. So I'm not going to make a conclusion
Thank you, Your Honor. Well, then I'm more comfortable with the words completely unacceptable, maybe not being as strong as I interpreted them the first time. So that's fine. That's fine. This is our life savings. And we sleep at night at 3 a.m. Wondering what damage was or was not done to the wall 5 feet away from us the day before. So, okay.
I can appreciate that.
I would like to add that we have been at this for 6 months, and the project is well into excavation below our property. So every day more damage may be occurring, and we have no idea of knowing what is happening.
I can appreciate that. Yes, Mr. Moeller.
Your Honor, I'd like to just address that point and actually pose a question to Ms. Wilson at the risk of putting her on the spot. But I did want to mention to the court March 3, 2023, Special Inspection Daily Report issued by Rocks Engineering, which is the Special Inspections Engineering of record. And if I am reading that report correctly, the contractor is on stage 4 of what appears to be a 5-stage underpinning process. And I'm just wondering if Ms. Wilson could address how much work has been done, how much work remains to be done, because this report left me wondering whether this work under the permit, which petitioners would have the court revoke, is going to be completed before the March 30 hearing. Ms. Wilson, again, my apologies for putting you on the spot, but can you update us on how much more work there is to do under the building permit?
I'll have to ask my client. I'm not up to date on the construction portion of this. I do know that a substantial amount of work has been completed at this time, though. I just don't know. It sounds like you know more than I do in terms of the stage, so I'll have to talk to Mr. Waldman.
No, fair enough. And just for the record, this March 3 report indicates that party walls were checked for any cracks. I assume if there were cracks, it would have been reflected in the report. Your Honor, the only reason I mentioned this is, again, I'm starting to wonder whether this whole exercise might be moot if, in fact, the work is done before we go to mediation or go to hearing.
It sounds like no one will call, at least that
we have an offer.
Can answer that.
It's not moot because...
Go ahead, Pat.
It's not moot and will never be moot because on the track that we're going, we will never know what has happened. They will cover over, put a new floor down, and we will never know how deep or what materials were used or what has happened on our property beneath our house. So it really, this is a DOD issue of non-disclosure. And the farther the project gets along, the more that is not being disclosed will be covered up. So it will go on into perpetuity if we do not understand and acknowledge with the parties involved what exactly has happened. The permit is one word. It says underpinning, and it doesn't say depth. It doesn't say what protections are being installed. It says nothing but underpinning. That is unacceptable.
And Your Honor, the building settles over time, and the second permit involved here is to put a penthouse on top of, again, undisclosed weight and pressure. We become the flying buttress of the penthouse, and the brand new foundation takes new weight for which calculations have never been offered to our engineers, who asked 3 times, and it's specified in the code in section 106 that calculations are to be made. So just because the cement might dry on the new floor doesn't mean the building isn't settling. And we absolutely insist upon the answers to the questions we always were entitled to receive pre-permitting, because it's not moot. And the scar left by the manner of permitting will live on for this property, this address, and may even affect ours for years to come. Answers not received. So.
All right. Thank you. I understand your position on that. All right. So there are 2 motions, I think, that were outstanding. The one is the motion to intervene, which I said we will rule on. And then the other was the motion for summary adjudication submitted by Mr. Mallof and Ms. Steele. And we also had a response from, I believe, Mr. Moeller on that.
I'm sorry, Your Honor. I missed the last thing you said.
I think you submitted a response to the motion for summary adjudication.
Yes, ma'am. We certainly did.
Yes. All right.
And Your Honor, regarding Mr. Moeller's comment, we did not ask for capitalized stop work order. In the code, stop work orders are issued by the department for misconduct or poor practice of permit holders. We have no idea what the permit holder is doing here, or what their skill set is, or what their practices are behind basement closed doors. Our objections are with the agency, and in that regard, then, the administrative law judges, I believe, on your panel are empowered to suspend permits and licenses consistent with, Title 2, 1831.09.9. The administrative law judge may suspend, revoke, or deny a license or permit. That's our request for our safety, for the integrity of the process that was not followed at its plain black letter reading, that we received no responses whatsoever except for one sentence after 6 months. We believe that a suspension of the permit, if we're in stage 4, we're almost done. Let's get these issues aired. Let our engineers view the answers and determine whether or not the project is viable and safe. And before the final cement gets put over the grave of what was our foundation, let's have the dialogue we never had. So we request earnestly that the suspension, even if it's temporary, be issued immediately by the court. Please.
Your Honor, if I may.
Yes.
Petitioner, having broached the law that governs this matter,
Yes.
I would just like to refer the court to 12 DCMR section 112.2, in which it states that the Office of Administrative Hearings shall not overrule the code official's technical determination or interpretation unless determined by OAH to be arbitrary and capricious. So, although you have the authority to revoke a license, it must be based on a finding that the issuance of the permit was arbitrary and capricious. And again, even if we go to hearing after the work under the permit is completed, we look forward to the opportunity to prove that our decision was not arbitrary and capricious, and that we gave full consideration to the concerns raised by petitioner. Now, they may not understand all the engineering involved, but our engineers satisfied themselves that the concerns raised by petitioner did not rise to the level of posing a threat to the structural integrity of the building.
Well, thank you, sir. May I speak, Your Honor?
Yes.
Yeah, well, I mean, that's fine had we heard something back. We heard nothing back. And I don't have a Ouija board or a crystal ball in my possession. We got no response package back.
our engineers were not allowed to do the job that we hired them to do.
They couldn't do the evaluation, Your Honor. So we waited for a detailed resolution. I'm sorry, Beth.
It was almost as if the more that we asked for information, the more our rights for any information were taken away. And the decision apparently was made very early on. It seemed to us, because we received notices that we would have, that the rules had all changed. We received an email that said, no, after the permit's issued, after they'd already decided to issue the permit without telling us anything. I mean, it's astounding to me that we could submit as many comments and objections as the NN required us to do and get no response whatsoever, and then have a permit issued that is a one-word permit. It's absolutely beyond the pale.
And Pat, if I may add, honey, Mr. Moeller is new to this. He's obviously not informed. We received nothing back. Whatever behind closed doors things were reviewed did not result in the two different detailed resolution reports in one package that were promised and attested to by the permit applicants. We did not receive a determination as is required from our request for reconsideration. All we got was one sentence, which I considered highly irregular and arbitrary and capricious. And there's a provision in the code that says, yes, the permit official can, if he or she is satisfied, issue a permit. But that can't be at the exception and rejection of all the settled neighbor notification rules that exist promising a response. And we are not aware of any determination that was made that everything is hunky-dory to issue the permit. This thing has been completely not documented over 6 months, and Mr. Moeller is misinformed. So the essence of our case, Your Honor, is arbitrary and capricious. It is that the code specifies on multiple occasions notice and notification in lowercase n, that the agency has built out an edifice over the years of capital N, neighbor notification. It's legalistic. It's actually scary for your average Bear resident. And we responded dutifully, and the permit officials and the code officials apparently looked completely the other way on an absolute arbitrary and capricious basis to the forms that they had themselves promulgated as allowed and as settled build-out for DC rules by 106.2, 18.3.1.2. They can't have it both ways. They can't send certified letters to us with the imprimatur of the DC government signed and attested to by the applicants, and then wake up the next morning and not say anything back to us. It is. Our case will go on convincingly to prove that this was rank, arbitrary, capricious, and premeditated conduct by the agency. They wanted to get rid of pre-permitting comment and resolution. That's the most logical way for new neighbors to proceed, not to proceed in silence with the machine then kicking out a permit. No, Mr. Moeller's not informed.
All right, thank you both for your comments. And I think the only person we haven't heard from is Ms. Wilson, and we'll give you an opportunity to speak to the motion for summary adjudication as well. Thank you. We also opposed the motion. I was not served the motion, just because I'm not a party, but Mr. Moeller provided it, and we would just largely agree with OAG and DOP's position. And I don't think a case has been made that this decision was arbitrary and capricious to the extent that it could be the result of a revocation of the permit and this type of motion. Thank you. All right. So again, after the two motions, we will issue written decisions on both of those. The mediation, you're welcome. The mediation, it sounds like Mr. Mallof and Steele haven't, it sounds like y'all have been talking and there is some offer on the table that you were hoping that the parties would consider. And so I do think mediation is an appropriate next step in this case. And so I think what we need to do to move forward is I will get some dates from you. I will propose them to the person who will be mediating the case, and then we'll get this scheduled. Try and get it scheduled within the next 30 days if possible, because I know you all want to move forward on this.
Yeah, Your Honor, after my misconduct, we are wide open for you. And that may mean I need to cook this dinner for the next 3 months, but I am, whatever date and time you pick, we are fine with.
All right, and so then let's look at calendars, Mr. Moeller.
Bear with me for one moment, Your Honor.
Okay. And then just to be efficient, we'll look at yours also, Ms. Wilson, just in case, you know, I have not decided how I'm going to rule on the motion, but just in case we'll at least have you available. Thank you.
Your Honor, my April is wide open.
Okay. My April is also wide open except for April 5th. I have another hearing that day. Okay. I'm thinking at this point just to, you know, our mediators can also be busy thinking about maybe end of April. So let's give them a few different dates. I'm looking at April 25th. That's a Tuesday. April 28th, that's a Friday. And then maybe another, let's say maybe early May, May 2nd. That's Tuesday. And then maybe...
Your Honor, that means the hearing's off on the 30th?
Well, you're going to, I think it's, yeah, we would postpone the hearing because we wouldn't have an evidentiary hearing yet and have mediation. So mediation would go before the hearing. But I think this way, the conversation, I think it sounds like you wanted to have with the department can happen. And I think having someone, you know, who is objective and neutral and kind of not with either side might be really helpful in this case, just to kind of hear out the issues and see if you can come to some resolution.
Okay. And Your Honor, regarding our emergency motion,
so I'm
not tracking very well. All right,
yes,
all right, thank you. That's the most important thing then.
Yes, and that will be before your mediation, yes.
Thank you.
Okay.
That we would sleep at night with a pause that I think no unreasonable person should argue with. Thank you.
Okay. All right, then I think that's how we'll proceed. I will issue an order regarding the mediation, and so you'll all have something in writing with the contact information. Typically, we do these by phone also, so it would be a remote hearing likely, unless the mediator, for some reason, you know, is interested in doing it another way, and they would let me know that. All right, do you all have any other questions?
Not from the respondent, Your Honor.
Okay, so what you can expect from me is we're going to get an order on both of the motions, the motion to intervene and a motion for summary adjudication. You'll also get an order reflecting that there will be a mediation in this case, and it'll give you the details. Typically, we start around 9 or 10 a.m. unless the parties have conflict on the dates that we've discussed. And they often take about 2 hours, I'd say, but I would give yourself a half a day whenever this is scheduled, just so you're not feeling rushed.
Your Honor, one small point. I'm not asking for sympathy. My mom's lived a great life, but today she did enter hospice at the age of ripe old 99.
Oh.
And I tease her that she can't remember what age she is, and I say 99. So she has entered hospice. It's a total wild card. She has been just amazingly resilient, and this is her second time in hospice. So there is some slight possibility that it might come begging, but at this point, we're all rooting her on, and I hope she graduates again.
Well, we're rooting her on as well.
Thank you.
And certainly we will entertain any motion for continuance if something happens, and we pray that it doesn't. All right, thank you for sharing that. Okay.
Thank you, Your Honor.
All right, anything else? Any other questions from anyone? All right.
No.
I think we've covered all the things that we needed to in the status hearing, and again, appreciate all of your time and your efforts. And I'm hoping we can move this forward and come to at least a resolution, if not through an evidentiary hearing, then maybe with mediation. All right. Well, thank you all.
Thank you. And we do want to thank the agency. We do want to thank the agency. We